Hello everybody, welcome back to our CMA classes. So let's resume our law class for CA final and CMA final students. So we have already completed section 7, section 8, section 9. Okay, so let's go for section 10. So what is about section 10? Do you remember there were 3 people who can go for the application to file for what? Corporate insolvency resolution process. Remember? 2 adjudicating authority. So first was the financial creditor, second operational creditor, and third the corporate debtor itself, okay, which means corporate applicant. So section 10 is about the corporate applicant. So let's go and start this. Initiation of corporate insolvency resolution process by the corporate applicant under section 10. So once the default is committed by whom? By definitely the corporate debtor. Okay? The corporate applicant, which means a company, may file the application to whom? To adjudicating authority. Yes, same process, right? Okay. To initiate what? Corporate insolvency resolution process. Okay, CIRP. So this is the same process which is actually involving for financial creditor and operational creditor. Okay, hope so this was easy and clear to you. Okay, along with that application, the corporate applicant have to file some documents, and they have to furnish some documents, and they are first of all book of accounts and such other documents, information which is related to resolution professional proposed to be appointed as the interim resolution professional. Okay, which means let me say it again, which is very similar, which is actually similar to the section 7 and section 9 points. Okay, first of all, book of accounts. This is one more new things. Okay, book of accounts and other documents. Okay, the name of whom? The interim resolution professional. Okay, the proposed name who is going to be appointed as what? Resolution professional. Okay, so the name is to be given. Okay, one new other new thing is special resolution or resolution passed for approving filing of application. We know what is special resolution and we know what is resolution. Okay, but let's read out what the law is saying here. Special resolution is passed by shareholder definitely of the corporate debtor. Okay, so what about the resolution? Resolution is to be passed by how much number of partners, which is 3/4 of the total number of partner of corporate debtor. Again, for special resolution is passed by shareholder, we know this. Okay, second, for resolution 3/4 of number of what? Total number of partner of corporate debtor. CD is corporate debtor. Okay, so we are going to take the 3/4 of the total number of the partners. Hope so this point was clear. So first thing which is to be furnished along with application, book of accounts and other documents. Second is that proposed interim resolution professional which is to be appointed, the name of that person. Third point is about the special resolution and resolution which is for approving filing of application. This is to be furnished along with the application. So it was clear to you, hope so. Okay, once this is done, what is going to happen? The adjudicating authority is either going to accept that application or going to reject that application. Same process, right? But within how much days? Within 14 days. Okay, within 14 days of the receipt of application. This is again similar thing for us. Okay, either if the adjudicating authority is going to accept the application if the application is completed, but if the application is not completed, in that case the adjudicating authority is going to reject that application. Similar na? Second, if no disciplinary proceeding is pending against whom? That proposed resolution professional. Okay, if no proceeding is pending against that resolution profession, okay, in that case the adjudicating authority is going to accept that application. Otherwise, definitely it's going to reject that application. Hope so this point was also clear. And this is also the similar point which was written in section 7, section 9, which says before rejecting the application by whom? By AA. So the AA shall give a notice to whom? Applicant. To whom? Definitely to the applicant. Okay, to rectify within how much days? 7 days. Hope so this point was also clear. So what is the last step which is going to happen? Commencement of CIRP, corporate insolvency resolution process, is going to happen from the date of admission of application by AA. Hope so this was super clear to you. So let's go for section 11, which says the person who are not entitled to make the application. So the corporate debtor, first of all, who is undergoing a corporate insolvency resolution process. A corporate debtor who is undergoing corporate insolvency resolution process is not entitled to make the application to AA under section 11. Hope so this is clear now. Let's go for the second point. A corporate debtor having completed, who have actually completed the CIRP 12-month preceding the date of making of application. Okay, so we are going to take the 12-month preceding, 12 months from preceding the date of making application. We are going to take that day. Okay, and to whom we are talking about? The corporate debtor. Okay, who have completed the CD, again completed CIRP from the preceding date, 12 months from the preceding date of making application. Okay, so this was also clear, right? So third point is the corporate debtor of whom? Of the financial creditor. Okay, the corporate debtor of whom? The financial creditor has violated any terms of resolution plan which was approved 12 months before the date of making application for initiating corporate insolvency resolution. Okay, so if any corporate debtor violates any law, in that case against that person is not entitled to make the application. Last, corporate debtor in which liquidation order has been passed. So there are 4 points. Number first, corporate debtor undergoing CIRP. Again for corporate debtor, we have completed 12 months. Remember, from the date of making application, okay, CIRP process. Third point is about, again, corporate debtor, financial creditor, remember, who have actually violated any law. Okay, fourth is about the corporate debtor in which liquidation order has been made. Okay, so this was 4 point under section 11. These people cannot entitled to make the application. Hope so this point was clear. So is there any time limit for completing insolvency resolution process? Yes, there is. So let's go for section 12, which says the time limit. The corporate insolvency resolution process shall be completed within how much day? Within 180 days from the date of admission of application to initiate such process, first of all. So do you think there is an extension of time limit by A? Yes. If the A is satisfied, okay, in that case 90 days would be extended. Okay, so can you tell me further extension is provided? Yes, there could be, but most probably there is no extension. Okay, extension is only given for the one time. And the maximum time limit where this process is to be concluded is that 330 days. So let's go for the things which the law is saying in this section. First of all, corporate insolvency resolution process shall be completed within how much day? Within 180 days. Is it clear? Yes. From the date of admission of application to initiate such process. Okay, which means once the AE have accepted the application, okay, by whom? By the financial creditor, by the operational creditor, or by the corporate applicant. In that case, the commencement of CIRP is going to happen. Okay, hope so this was clear now. Then this law is saying, this section is saying that the time limit for CIRP is 180 days. Okay, but is there any extension granted? Yes, extension of time limit if A is satisfied as it thinks fit, but not exceeding 90 days. Is it clear? Yes. Extension shall not granted more than once. Okay, so there is only one time extension possibility. Okay, CIRP shall mandatory be completed within 330 days from insolvency commencement date. From ICD. Okay, so within 330 days it should be completed. The process should be completed from insolvency commencement date. Okay, so hope so this section was also clear to you. Let's go for section 12A. So section 11 was those person who is not entitled to make the application. 12 was of what? The time limit of doing CRP process. Okay, So 12A, withdrawal of application. Do you think the withdrawal of application is possible in this section, in this chapter? Yes, for this section withdrawal of application is possible. But is there any criteria for this? Yes, again there is a criteria that 90% of voting share of the committee of creditor in such manner as specified. It should be approved by 90% of member of voting share of committee of creditors. Now we want to know what is this committee of creditor. There is another section of committee of creditor. We'll know this later. Okay, so the adjudicating authority may allow the withdrawal of application made by how many people? Approval of 90% of whom? Voting share of the CC. CC is committee of the creditors. Okay, which as may be specified by the law. Okay, so for withdrawal 90% of voting share of committee of creditor is required. Okay, otherwise not going to happen. Okay, withdrawal is not going to happen. Withdrawal of application is not going to be possible. Okay, let's go for section 13, which says about the declaration of moratorium and public announcement. Okay, so once these things are done, the CRP process is done, what is going to happen? The AA, the adjudicating authority, shall make an order with respect to following things. Okay, first of all, appointment of interim resolution professional is going to be happen. So first point says about the appointment of IRP, interim resolution profession, is going to happen. Okay, second, public announcement is to be done, which is saying initiation of CIRP. Okay, which is telling the public about the initiation of CIRP. Okay, corporate insolvency resolution process have been initiated of this company. Okay, hope so this point was clear. Okay, third is about the declare a moratorium. Now there are three things involved in this section 13. Okay, and three things itself contain a different section each. So let's go for it now. Section 14, moratorium. Remember, this is one of the thing mentioned in section 13. Okay, so let me write it here. Section 13, 1 point. This is one of the point. Okay, moratorium. So what is that? On the insolvency commencement date, the adjudicating authority shall by order declare a moratorium for prohibiting all of the following things. So the company cannot go for these things. First of all, the institution of suits or continuation of pending suits or proceeding against the corporate debtor, which says if any suit is actually already pending against whom? The corporate debtor. Okay, including execution of judgment decree or any order of court, tribunal, arbitration panel or any other authority, it is going to cease there. Nothing is going to happen. Okay, whatever the case is going to be there, the suit would be not going to declare. Okay, so let me say it again. The institution of suit or continuing of pending suit or proceeding against the CD, which is corporate debtor. Okay, including execution would be prohibited. Okay, would be prohibited. Hope so this point was clear to you. Let me highlight this point. Just a second, and let me highlight this point, which is institution of suit or continuation of pending suits or pending against CD is going to be prohibited. Hope so this point was clear, right? Let's go for the second. Transferring and keeping, electing or disposing of by the corporate debtor of any asset or any legal right or beneficial interest, which means transferring of first asset, right? Transferring of asset is prohibited. Transferring of any legal right is prohibited. Transferring of any beneficial interest is against prohibited. Hope so this point was also clear to you. Let's go for the third point, which says any action to recover or enforce any security interest created by whom? The corporate debtor. Okay, in a respect of property, including any action under securitization and reconstruction of financial asset and enforcement of security asset act 2002, which is simply saying any action which was recovered. ठीक है, which was recovered, first thing, or enforce any security interest which was created by whom? Created by the corporate debtor, by the corporate debtor. Hope so this point was clear. In respect of in related to Sarfarasi, remember act, there is one act under section Sarfarasi 2002. Hope so we will cover this chapter also. Okay, so don't panic. So let me say it again. We have already covered 3 points. Okay, and fourth is recovery of any asset by owner or lessor or such property occupied by or is in possession of corporate debtor. So these are the things which the corporate debtor, these things would be prohibited by the corporate debtor. Okay, either they cannot transfer the goods, the rights, the assets. Okay, they cannot take in possession or they cannot recover any assets. Okay, under Sarfarasi 2002, the action to recover or enforcement to security interest created by the corporate debtor would again be prohibited, or any suit, any institutional suit or continuation of pending suit or proceeding against CD would again, what is going to happen? Prohibited under this section. Okay, so hope so section 14 was clear to you. Let's go for the other points, remaining point of this section. First note says the above provision shall not apply to such transaction as may be notified by central government with any financial regulator, and second, this is not going to apply to a surety in a contract of guarantee to corporate debtor. Okay, so these two cases it's not going to apply, the prohibition is not going to apply. Hope so this point was also clear to you. Let's go for the other thing. The order of moratorium shall affect from the date of order till the completion of CIRP. So this moratorium order is going to apply from definitely the process, right, till the end of that CIRP process, which is corporate insolvency resolution process. Okay, but there is two exception which says the moratorium shall cease to have effect if at any time during the CIRP process the adjudicating authority approves the resolution plan. Okay, if the A have itself approved the resolution plan, in that case that prohibition is not going to be validated. Okay, second, pass an order for liquidation. If any liquidation order is passed, okay, of corporate debtor, in that case again this prohibition is not going to be validated. Hope so this point was clear. So section 14 was of moratorium. This was one of the point written in section 13, and section 13 says that declaration of moratorium and public announcement, and whom the IRP, appointment of IRP. So we have already covered 1 point, section 14 moratorium. Let's go for the 15th section which says the public announcement, of insolvency resolution process. So such public announcement shall contain following information: the name, address of corporate debtor under CIRP, name of authority with which the corporate debtor is incorporated or registered, the last date for submission of claims as may be specified, details of IRP who shall be visited with the management of the corporate debtor and be responsible for receiving the claims. Okay, or if there is any penalty for false or misleading claims, this have to be again written in the public announcement. Okay, this is all one of the things which is to be mentioned. The date on which corporate insolvency resolution process shall close and the manner of making public announcement as may be specified. Okay, so these are the things which is to be written in the public announcement. Okay, under section 15. So we have also completed this point which was written in section 13. Remember, there is one more point, right, which was of appointment of IRP, and that is going to be section 16. Let's go for it, guys. So remember, we have covered 7 section. In that there was something written like financial creditor can appoint the resolution professional, right? They can propose the name of resolution professional to AA if they have no disciplinary proceeding pending against that person. Okay, so in this case, if no proceeding is actually pending against the proposed name given by the financial creditor or the operational creditor, okay, then A is going to take that name, okay, for the further process. ठीक है, let me read it again. Okay, then we'll let to know what is this section saying. Section 16 is about the appointment and tenure of the interim resolution professional. Okay, so for where the application for the CIRP process is made by first corporate creditor, remember under section 7, right, the resolution professional as proposed in such application shall be appointed. Definitely, if no application, if no disciplinary proceeding are pending against whom? Against him, okay, which is the name proposed by financial creditor in the application. Okay, so the AA will appoint that people. Okay. Second, the corporate debtor. Remember there was one more, operational creditor. So let's complete first of all operational creditor point. If the operational creditor have given the name, given the proposed ways to be appointed, okay, they have given the name of resolution professional. In that case, if A is satisfied, if no proceeding pending, there is no proceeding pending against that person, in that case that person is going to be appointed. Okay, but what if the operational creditor have not given the name? Okay, in that case what is going to happen? The adjudicating authority is going to ask the board to give the reference, okay, to refer someone which is to be appointed as the interim resolution professional here. Okay, so let's go for the third point, which says by operational creditor where no proposal of interim resolution professional is made. In that case, A shall make reference to whom? To board for recommendation of insolvency professional who may act as interim resolution professional. So what is going to be the time limit? Within how much time limit the board have to give the reply to AA? Within 10 days. Okay, so let's read out. A, the adjudicating authority, shall make reference to whom? The board. Okay, hope so this point was clear. Okay, and board shall recommend within 10 days, 10 days from the date of reference, the date of reference. Okay, so board is going to give within 10 days, it's going to give the name of that person who is going to be appointed or who should be appointed as the IRP. So name of that IP is going to be given to AA, where no disciplinary proceeding are pending against that person. Okay, so this was the case where operational creditor have not given the name of that IRP person. Okay, but what if it was given by the OC, by the operational creditor? Okay, if in that case what is going to be happen if no proceeding pending is actually, the case is not pending against that person, in that case that person is going to be appointed as IP. Okay, so this is what saying by where the operational creditor under section 9, the resolution professional as proposed such application shall be appointed as interim resolution professional if no disciplinary proceeding are pending against him. So for these two people we have completed. Number first, financial creditor, right? For operational creditor there were two things. Okay, if what if the proposed, they have not given the name of proposed interim resolution professional, in that case the A is going to refer whom? The board. The board have to give the name within the 10 days. Okay, 10 days from the reference given by AA. Okay, and what if they have given the name of that person? In that case, if no any pending proceeding is, there was no pending proceeding against that person, in that case that person is going to be that IR. Okay, so there is one point remaining. What if point 2 says by the corporate debtor itself under section 10. Yes, the resolution professional as proposed in such application shall be appointed as interim resolution professional if no disciplinary proceeding are pending against him. So this was similar thing. Okay, so it is clear now. Under section 16, appointment and tenure of interim resolution professional is written. Hope so this point was clear. Let's go for section 21. As I told you, there is one thing. What is this committee of creditor, COC? Let's go for it and check out what are the points written here in this section. The interim resolution professional shall, after collation of all claim received against the corporate debtor and determination of financial position of the corporate debtor, constitute a COC. Okay, the committee of creditor shall comprise all the FC, financial creditor of the CD, okay, which means the COC, the committee of creditor, should constitute of whom? Financial creditors, of whom? The corporate debtor. Okay, this was clear. All the decision of committee of creditors shall take by vote which is not less than 51% of voting share of the financial creditor. Hope so this point was also clear. Okay, so the decision should be taken for at least 51% of voting share of financial creditor. This was also clear. Let's go for section 22, which says about the appointment of resolution professional. Okay, don't be confused here. Let me summarize everything. Section 7, section 8 and section 9. Okay, what happens? These three people have to give the name. Okay, the name to A, okay, for interim resolution, okay, interim resolution professional, okay. But what if they have given the name, and what if they have not given the name? Okay, what if they have given the name? In that case, if no proceeding is pending against that people, they are going to be appointed. But what if they have not given the name? In that case, in case of operational creditor, what is going to happen? The A will refer to board. Okay, within 10 days, the board have to give the name to the A. Okay, in that case, again that person is going to be appointed. Okay, once the professional are appointed, there is chance that the company can again remove them. Okay, let's go for this section now. Don't confuse. Okay, so is there any time limit that COC should be constituted within this much time limit? Yes, within 7 days. Let's check from which 7 days. Okay, so the first meeting of COC, committee of creditors, shall be held within how much day? Within 7 days of constitution of committee of creditors. Okay, so the first meeting, the meeting of COC should be held within 7 days of constitution of COC. Hope so this point was clear. Okay, interference meeting the COC may be major vote of not less than 66% of voting share of the financial creditor. Resolve if they actually want to appoint. Okay, if they actually want to appoint the interim resolution professional, in that case they should hold 66% of voting share of financial creditor. Otherwise they cannot replace that name, okay, which was given by AA or by board. Okay, or if they, let me read it again. So for interference meeting, the committee of creditor may by major vote of not less than 66% of voting share of whom of the financial creditor is required to resolve first if appoint the interim resolution professional. Okay, if they want to appoint interim resolution professional, okay, or they want to replace the interim resolution professional by any other resolution professional. In that case also, what is going to happen? The first meeting of COC, 66% of voting share of financial creditor is required, okay, to appoint or to replace the interim resolution professional. Okay, note where the COC, the committee of creditors, resolve to replace the interim resolution, it shall file application to AA. Okay, once they have appointed or they want to replace this person, interim resolution professional, okay, once they have actually appointed that person, interim resolution profession, in that case they have to file the application to AA, and further that A is going to give that information to board. Okay, and if board within 10 days they have not given any reply, so what is going to happen? The name given by the COC, the committee of creditor, okay, which name? The interim resolution profession, okay, the IRP name given by whom? The COC would be granted. Okay, that person would be IRP, but till how much date we have to find it now. Okay, so let's go for it. Where the note says where the committee of creditor resolve to replace interim resolution professional, it shall file application to whom? The AA, right? for appointment of proposed resolution professional along with the written consent from the proposed resolution professional in a specified form. Hope so this point was clear. Okay, so there is some further confirmation is to be done. We say the name of resolution professional proposed by committee shall be forwarded by AA to board for its confirmation. Okay, so within 10 days the board does not confirm the name of proposed resolution professional. In that case, the AA shall order direct the interim resolution professional to continue their function as the resolution professional until such time is confirmed the appointment of proposed resolution professional. Okay, if within 10 days no reply is given by board, the AA will give information, will reply to the committee of creditor, and they will say you can continue with them, continue with IRP. Okay, but till how much day, again let me say it. Okay, the AA shall by order direct the interim resolution professional to continue the function as the resolution until such time is confirmed the appointment of proposed resolution professional. Okay, so that person can continue as IRP, that person can continue the IRP until such time is confirmed the appointment of proposed resolution professional. Okay, so that's it guys. In this section we read that section 22 appointment of resolution professional, right? So first meeting should be held within 7 days of constitution of COC, right? 60 if they want to appoint or replace that person, okay, that professional, and they want to appoint some other interim resolution professional, in that case they have to notify to AA in written. Okay, and what is going to do, the A is going to do that, A is going to refer to board within 10 days. If there is clarification given by board, in that case that would be apply. Okay, that is going to happen, will be the final order. Okay, but what if no order is passed by the board? In that case the A will give the reply that you can continue until some other person is appointed. Hope so this was clear. This was section 22 in which we read appointment of resolution professional, committee of credit under section 21, appointment and tenure of professional 16. Okay, 15. So tell me the section here, the interim resolution professional and public announcement and declare a moratorium. Moratorium section was 14. Okay, so let's write here section 14 was of moratorium, section 15 was of public announcement, and section 16 was of appointment of interim resolution professional. So that's it guys. Do the revision regularly, stay consistent and be positive, stay loyal to your studies. That's it. This is Soumya Santosh. We'll meet in our next session. Till then, good night. Toodles guys.